to situate the discussion and the work in this booklet in the context, in the current context, and let me say what I mean by the current context. A context in which there is an overwhelming focus on criminalization and the law as the engine for social change, particularly around concerns of sexuality. And part of this comes as well, there's been a long struggle, historic struggle, but also part of this comes from a very publicly orchestrated, visible 2013 advocacy and campaign, which resulted in this huge set of changes in the law. And as a result of which there has been an expansion of criminalization and increase of punishment, and it has in a sense set a benchmark that if we are unhappy with something, we identify the gaps in the law and then we ask for more. And in a sense, legal responses or law reform has become the first impulse when we find the law is not responding. Even as we speak, there are many issues that are now being tabled by various sets of stakeholders within the women's movement, outside the women's movement, by the state, which are seeking criminalization. And that sort of has become, in a sense, epitomizes state will and a goal that is very tangible. The assumptions that this brings with it is that if the law indeed were perfect, we would actually not have the problems we are having. And it would deliver, and we would find a different context or a different social context. And that deterrence works. Or at any rate, deterrence is a very effective means of social change. So I think that within this context, what the book is doing, or the booklet is doing, is unpacking the law in relation to rape, around which the longest struggle for change has taken place in terms of going 30-35 years, and looking at what insights that experience might give us into understanding what the possibilities and limitations of law are. So if we look at this struggle, which spans 30-35 years, it has been exclusively around the issue of sexual violence, mostly around rape. And it was necessary because, as we know, the law was extremely, in a sense, inadequate. There were problems deeply sort of visible in it, very obviously visible in it, and also it didn't recognize several sets of offenses which were very commonplace and fairly serious. So it became necessary. But so in the course of this struggle, what we've also, what we try to show, what in each chapter is that there hasn't been a parallel effort to decriminalize consensual sex. So the focus and the vocabulary of public discourse has been exclusively sexual violence and victimhood. We see constantly in each chapter linkages being made with 497 on adultery, 498 on enticing a married woman, the wife of a married woman, and 377, which is, as we know, unnatural sex, or the provision which criminalizes homosexuality. Which is not to say that 377 today, there's sort of we are at a different position where several movements have sort of joined in, both in solidarity and to participate in the struggle. But these are a few examples which have historically been left out. If we look at the earlier years, right until say 2000 almost. And thereafter, it's not been an integral part of the conversation on sexual violence and the law. The other things that are not part of the book, but I would like to add on, just so that we have that in the horizon, is in relation to sex work, in relation to 125 CRPC, which is on maintenance to a woman, and which is conditional upon her chastity, obscenity laws, indecent representation of women, and much else. So, in terms of what I try to do is to bring out the statutory inconsistencies where we talk about achieving a certain definition of consent, but at the same time not addressing any of the other provisions, even in passing, which have criminalized consensual sex. And then, of course, there is the focus on judicial reasoning and judicial interpretation, which I think within the women's movement and academia much has been said about. But, you know, a lot of it has been said only to tinker further and further with the law. So much so that a lot of what we call gender stereotyping by the judiciary has resulted in the 2013 amendments and seeing that the judicial discretion itself has been taken away. So there's a high minimum sentence and no discretion to the judges to reduce the sentence for any reason whatsoever. But I also then make a comparison showing how judicial attitudes and narratives, and indeed attitudes of all the functionaries within the legal system, will remain subjective and have remained subjective despite successive changes, to the extent that even in relation to atrocities, where it would appear to be very obvious because there's a clear constitutional framework and a legislation, it is still treated as any other routine case of sexual violence. So what I'm saying is that there is a real danger. We are sort of we find. I feel that confronts us in expanding criminalization, because we have increased punishments, which we don't really talk about. The only aspect of punishment that we are uncomfortable with is death penalty, which is sort of the only thing that we sort of persistently critique. And not only have we reduced judicial discretion, but we have increased the number of offences which fall under the strict liability offences. So if there is sort of with an increase in age of sexual consent from 16 to 18 years, any consensual sex with an underage girl falls within the strict liability category, as do, you know, even amorphously defined offences of power and domination, economic and social domination, which lend itself to multiple interpretations, which is a strict liability offence. Okay, that time is up. So I'll use just two more quick points, which is to say that the most glaring example that I want to sort of put before us is the discussion we are seeing unfold over 2 years, because the template for more criminalization is a continuing one. We have currently a PIL in the Delhi High Court, which seeks to criminalize marital rape through removal of the exception. And while it bases itself on the right of a wife to consent or not to consent, adultery and enticing away a wife are not part of the challenge. So it is purely, again, related to a singular aspect of sexuality, which is violence, and that vocabulary. So I think, yeah, those are the main points I want to table. That with the judiciary, we have introduced, there is new vocabulary in terms of, instead of using habitual to sex, they now use the word promiscuous. So that's the big shift. But what we are seeing with this unfold is we've lost sight of two important things in the last couple of years, with a kind of intensified focus on eliminating sexual violence, is the need for decriminalizing, which I think is huge, and also in terms of finding other ways of talking about sexuality, which really underpins the whole understanding of what is violence, what is not violence, and so on. What is transgression, what is not transgression, what's okay, what's not. So hopefully the conversation